You're watching Court TV. I'm Kelly Craft in today for Ted Rollins. Thank you for being with us. We're going to turn now to Massachusetts, where Brian Walshe is back in court today for a competency hearing. Walshe was set to go to trial for the murder of his wife last month, but his trial was delayed after a judge ordered Walshe to undergo a mental health evaluation. Prosecutors allege Walshe murdered and dismembered his wife, Anna, on New Year's Day in 2023. Her body has never been found. Before we get you back into the courtroom there or into court, here's Court TV crime and justice correspondent Matt Johnson with more on this case against Brian Walshe.
No comment from Brian Walshe after he was charged with the murder of his wife, Anna Walshe, the missing Massachusetts mother of 3 young boys. And while he's not talking, prosecutors are piecing together a timeline of what they say he was doing in the days after her disappearance. Prosecutors say that Anna Walshe was last seen here at her Cohasset home on New Year's Day. Anna was last seen at home between 4 and 5 a.m. by a family member. Walshe told police that he had slept in that morning, but prosecutors say that he was actually awake and searching disturbing topics on his son's iPad.
At 4:55 a.m. on January 1st, he searched how long before a body starts to smell.
The very next day, more Google searches.
There were also more Google searches on January 2nd. At 12:45 p.m., Pat saw best tool to dismember. At 1:10 p.m., can he be charged with murder without a body? At 1:14 p.m., can you identify a body with broken teeth?
Prosecutors say that on January 2nd, Walshe came here to this Home Depot store, located in Rockland, Massachusetts, 9 miles from his house. He spent $450 on cleaning supplies.
Items included cleaning products, mops, brushes.
On January 3rd, prosecutors say Walshe drove to an apartment complex in Abington, 16 miles from his home, where they say surveillance video shows him hoisting a heavy garbage bag into a dumpster. At 4:48 p.m., prosecutors say Walshe drove to a second apartment complex in Abington. And at 5:10 p.m., investigators say he threw items away into a dumpster in Brockton. Then on January 6th and 7th, police searched the Walshe property in Cohasset. Prosecutors collected a lot of evidence in the basement of this home, including DNA blood evidence and 2 knives. On January 8th, Walshe was arrested for misleading police in his wife's missing person investigation. The next day, he was arraigned and pled not guilty. Then on January 17th, prosecutors announced that he would be charged with her murder. The next day, he was back in court.
The defendant is now before the court charged with murder of his wife, Anna Walshe, as well as disinterring of a body.
Let's go into court now for the start of that hearing.
Welcome, as I said, to counsel, and welcome to Mr. Walshe. I have a few things on my agenda. The first one, which is over here, is the competency. I've now received a report from Bridgewater State Hospital, a comprehensive report from Dr. Ryan. And in that report, Dr. Ryan concludes that the defendant is competent and ready to stand trial. And with that finding, which I accept, I had a brief conversation with the side of the bench. What's the defense's position? I just want it on the record, on the public record, with regard to the defendant's competency.
2 things here. 1, we're not contesting the competency finding. 2, we've had conferences with Dr. Ryan. We had them last night. What he asked us to do, is he is concerned that changing the Bridgewater to the jail may have an adverse effect on this report. He wants us to advise us and ask us to inform the court of his concern about that. He said that's not his lane, but we want to let the court know that we have this concern, and we'll bring it to the court's attention as soon as we think that they might be posing a problem. We're also informing the jail But other than that, we're not contesting.
All right. As with any case and any time, in my experience, the defendant goes to Bridgewater and then is returned to the facility, there's always a transition period. He's been there for 40 days now and has gotten, as I understand, into a routine. And that routine is going to be changed as he moves back to the House of Correction. So understandably, there will be some transition period, and alerting the facility knows this. They deal with this quite regularly. But I understand your intent to alert me to it, and we'll have some time here, I believe, between the time that we're picking a jury in this case and the time. I'm not suggesting that you're not working at that time, but the defendant's role in that is significantly different than it is when we're actually actively engaged in the trial. So hopefully that'll give him a nice time to settle back into the House of Correction. But obviously, if at any point you become concerned about that, I know you won't hesitate to raise it with me.
Thank you.
All right. So, let me, and I discussed this with you at this side of the bench as well. I received some edits from the defense to the questionnaire, which I will incorporate into the next version of the draft questionnaire. It's always a draft until the minute that I finalize it and send it to that pool of jurors. Speaking of that pool of jurors, somewhere on my desk, I have the updated numbers. Who knows what the yield will be, but I expect to take about 70, if I can, 60 to 70 jurors a day. In my experience, it's hard with the questionnaire, even without doing all the copying, to get through more than that number in a day, and there are other cases that are starting on Tuesday. And so if we can accommodate those, we will. We'll have to see what the draw is. The expected number is 105 now for Monday, and we're going to hold those over to Tuesday because, as you know, we're doing the final trial conference on Monday, and then we'll start the impanelment on Tuesday. So it looks like 105, 126, 121, 68 on Thursday, but those people will be pushed and held over till Friday. So we'll have a full group of some number of people to work with in getting a jury next week. And then jurors are here also on Monday and Tuesday of the following week. And I think we're the only game in town. That is, I don't think anybody else is paneling on Monday and Tuesday. Our intent is, if we get a jury during that allotted time, we will start the trial, the substance of the trial, on 12/1, the Monday after the Thanksgiving holiday.
All right, we are watching that competency hearing that's taking place in Massachusetts. We are gearing up for this trial. This is going to be Court TV's next biggest trial that we're going to cover here. What the judge is deciding right now is if Brian Walshe is fit to go to trial for murdering his wife. Let's go ahead and bring in criminal defense attorney Michael Gottlieb to talk about what we were hearing there. This is a competency hearing, Michael. Kind of talk about why that's taking place in the first place.
So a defendant cannot be brought to trial unless the defendant is competent to proceed, meaning they have to understand the roles of all the actors, the judge, what the judge's role is, what the prosecutor's role is, what the defense attorney's role is. They have to have an ability to assist, to behave in court, to testify relevantly. And it seems like he was sent away for evaluation. He was gone for 40 days. The judge has made a determination based on the report that he is competent. And it doesn't sound like the defense team took issue with that, only they wanted him to get reacclimated to the new prison setting that he is in. And now the judge is setting the trial schedule.
In regard to jurors, so jury selection is going to begin next week. From a defense counsel's standpoint, Michael, who would you be looking for to sit on the jury?
So, that's an interesting question. When we pick juries, we play amateur psychologist in terms of trying to figure out who's going to be the right person to be selected. I wouldn't want anybody who's been divorced. This is a situation where, obviously there was some kind of strife. They found evidence of the murder in the house. They found him doing things. There's circumstantial evidence. So you're going to want people perhaps that are very analytical, who are going to want more than circumstantial evidence, people who haven't been in a bad relationship, people who are going to want strong scientific evidence, DNA, blood evidence, maybe stronger than what the government seems to have in a case like this. But it's always very difficult to know where people are going to land. Very hard to pick juries and decide who you want before you have the opportunity to speak with them and really know what they bring to the table.
Yeah, good point there. Yeah, the jury selection is going to begin next week. I believe she said she's going to start bringing in 60 to 70 people. So, of course, we're going to follow that and bring our viewers up to date on all the developments in that case that will be taking place in Massachusetts. Michael, thank you. We're going to squeeze in a quick break, getting close to 12 o'clock. But you can see we have two jury clocks up right now, one in Truesdale that's taking place in Cedar Rapids, Iowa, the other in the Florida v. Tower case. We'll squeeze in a break. We'll be right back.
A former porn actor caught in a deadly father-son love triangle.
I'm not going to stop fighting to prove my innocence.
The Love Triangle beheading trial. Live coverage today on Court TV.
Sunday nights on Court TV. Join us for a night of food, friends, and our favorite legal dramas. It's Order in the Court. And this week, we're binge watching Bull. Sundays on Court TV.
Back now to Massachusetts, where Brian Walshe has just been cleared to go forward with his murder trial. Walshe is charged with first-degree murder in the presumed death of his wife, Anna, who was last seen on January 1st of 2023. The trial was initially delayed after a judge ordered Walshe to undergo a mental health evaluation, but he has now been cleared. Let's go in now for more of that hearing.
Thanksgiving holiday. Everybody on board with that schedule? All right, good. Let me next address, and then once I do this, I'll certainly turn it over to you. We're going to have our formal, really today's purpose was to address the competency, but to the extent that I could pick off issues that aren't technically motions in limine, but other important motions to the parties, I focused on those today. And I am prepared now to make a ruling on the change of venue paper. That's paper number 219, and I'm going to read that into the record now. Mr. Walshe has moved for a change of venue on the grounds of extensive and prejudicial pretrial publicity that he asserts has tainted the jury pool so as to deprive him of his right to a fair trial by impartial jury. Alternatively, the defendant seeks an order that prospective jurors be selected from outside of Norfolk County. In support of his motion, the defendant has submitted evidence of extensive national and local media coverage of the case, beginning on January 6, 2023, after Anna Walshe was reported missing, and continuing till the present day, as well as evidence of social media engagement with this case. After careful consideration of the defendant's motion and the exhibits provided to the court, I'm denying the motion and the request for alternate relief for the following reasons. The court may order a change of venue where there exists, quote, and it exists in the community where there is a prosecution is pending so great a prejudice against the defendant that he may not there obtain a fair and impartial trial. And that cites back to Massachusetts Rule of Criminal Procedure 37 and Commonwealth versus Clark 432 Mass 1 at 6, a 2000 case. A judge has substantial discretion to transfer a case to another county based on pretrial publicity. And according to Commonwealth versus Gaynor, 443 Mass at 245 at 259, pretrial publicity, even even pervasive adverse publicity does not inevitably lead to an unfair trial. A change in the place of a trial should be ordered with caution and only after the defendant has established, based on a, quote, solid foundation of fact, that the pretrial publicity has created presumptive prejudice. And to that I cite to Commonwealth versus Hart, 493 Mass. 130 at 141, and Commonwealth versus Tulin, 460 Mass. At 452, pinpoint site 462, 463, a 2011 case. Presumptive prejudice exists only in truly extraordinary circumstances where the trial atmosphere is utterly corrupted by media coverage. And, quote, the entire venire may be presumed prejudiced, regardless of specific voir dire procedures utilized. This standard is only met if the publicity is both extensive and sensational. And to that I cite to Commonwealth versus Hughes, 467 Mass. 395, 406, a 2014 case. In assessing whether pretrial publicity precludes a fair trial, the court should consider additional factors such as, quote, the size of the community, the length of time between the peak media coverage and the date of the trial, and whether the news stories contained a confession or smoking gun rather than merely being unkind.